Order. First on the agenda is topics from the floor that are not on the public hearing agenda. Anybody wants to make any comments? Is anybody online?
Two people just joined, so give me a minute to ask.
Okay. No? Okay, so our planning commission meeting minutes stated April 14th, 2026. We have time to review those.
Which then we accept them.
Okay. Second.
I
Aye.
Have our public hearing. It is now 6:31 PM. The public hearing is now open. This is a quasi judicial land use hearing. The subject of this hearing is a request for a conditional use permit. The subject property is identified on the county assessor's map as lot 184 South 15th Street on map 4N 1W-4AC-5501 and 5502. The applicant and owner is Hunter Christensen. Because quasi judicial proceedings require the observance of certain procedural formalities, we will take a few moments to cover some preliminary matters and required statements. Does any member of the commission wish to declare a potential or actual conflict of interest or bias in this matter? No? Does any member of the commission wish to declare any ex parte communications or site visits? Does anyone from the audience object to the ability of a commissioner to make a fair decision? Generally, the order of proceedings will be as follows: required statements, staff report, applicant's presentation, those in favor of the application, neutral testimonies, those opposed, rebuttal by applicant, final questions, close of record, deliberations and decision. The following statements are required to be made at the commencement of the hearing pursuant to the city code and ORS 197.7975. The following is a list of applicable substantive criteria for this decision, SHMC 17.100.040. All testimony, arguments, and evidence must be directed towards the applicable substantive criteria as described or other criteria in the comprehensive plan or land use regulation, which the person believes applies to the decision. Failure to raise an issue, including constitutional or other issues relating to the proposed conditions of approval in this hearing, in person or in writing, or failure to raise an issue accompanied by statements or evidence sufficient to afford the approving authority an opportunity to respond to the issue, precludes appeal to LUBA, the Land Use Board of Appeals, on that issue and precludes an action for damages in circuit court. So now we can begin our hearing. I have a staff report.
Thank you, Chair Cisco. So we have a conditional use permit before you tonight for a site on South 15th Street. And this is just a matter before you that's about 12 years in the making. So this building has been there for many years. In some of our preliminary meetings, Al Peterson, well, who I'm sure will speak on it, talked about playing for the Little League that the business sponsored, Arnie Trucking, I believe. So it's been there a long time. Back in 2013, 2014, there was a proposal to build an addition on the site. And it moved along a bit, but then stalled and ultimately wasn't finished. So over the years, the permits expired and it was finally acquired by a new owner in October of 24, if I remember right, it's in the staff report. And it's been kind of a process to get to the point to help renew the permitting because it's all expired. The building permit expired, the land use permit expired. And if it wasn't for the outdoor storage component that's here, it wouldn't be before the planning commission. The applicant's ultimate goal is to get a tenant. And so some of the things I want to talk about is being a little bit more broad in the uses that are possible here. Because maybe a different tenant than just someone who is a craftsman will show up. And so I'll talk about that a little bit, and that, you know, there may be some tweaking to the conditions. If it wasn't for the outdoor storage component, this would just be administrative. And the reason for that is in the Holton Business District, the zoning district that we're at, outdoor storage as a component of any kind of permitted use simply kicks it up to the planning commission as a conditional use. So that's why we have this for you. As far as the land use file history, it goes back to 2004, and that's when it was zoned general commercial. A little bit different standards back then. One of them had to do with what kind of use was possible. I remember talking to my predecessor about it, Skip Baker, and he put it into this muffler shop category because it was the best thing that fit. But it wasn't really ever, I don't think it was ever it serviced automobiles. It was a mandrel business. So back in 2014 with the addition, since we have uses that clearly say that that's okay, we made sure that was clear. So there wasn't any use issue that came up later. Now, the current owner started cleaning up the property. Our building official talked to him, and this goes back to December 24, January 25. And he came into the office and we talked about the various permitting and stuff like that. And at that point, I would say he was a little cantankerous about things, kind of just stormed out of City Hall. And so it's been a little bit more work to get to this point, as you may have read in the report. We've been to municipal court and stuff. But he's been a little bit more open and understanding of things, which is good because some of the discussions helps me think about this and some of the things that I'll talk with you today. Interestingly, one of the things that's not in the city staff report or the applicant's narrative, the previous owner did inquire twice about reinvigorating the permitting. The first time it was in person. Back then, you know, we said, well, we have to renew these permits and we have to talk about the site improvements such as the street trees. And that really bugged them. It seemed like that was a reason why he didn't want to proceed with it, because it bugged him quite a bit. A little bit later, his representative, I can't remember his name, but at the time, this tall, skinnier guy, I think he moved to Montana since, but he had this external leg brace on because he fell off a roof. So I remember him pretty well. So he asked on Adam's behalf, and we talked about the same thing, you know, the site improvements apply. And so they never followed with any application, and ultimately was purchased by the current owner. But that whole tree thing is something that kind of stuck with me. We'll go back to 2014. Al was pressing the city about honoring its street tree code. And it makes sense because it was clear to me that the city, in many respects, kind of ignored it for a long time. And so because of all that happening at that time, he was compelled to include the street trees on the plan. And I've had a lot of time to think about this property, thinking about, what happened back in that time period, the interactions with the previous owner, Adam, and the trees, and the fact that this is, it's a building addition. How much do you require for that? And so one of the things I talked with the owner about, and I want to talk with the planning commission about, because one of the things we have to think about is screening. We have a parking lot and it's screened on the various sides, but the two sides we're going to talk about more today is the south side, which abuts a single family dwelling, and the occupants of that dwelling are here. I imagine we'll speak about it. And then the side along the street. So I might as well talk about the part along the street. So whenever we have parking lot larger than 3 spaces, it's supposed to be screened. And one of the differences between the general commercial zone and the Holton Business District zone is the vision clearance standards do not apply. So what am I talking about that? The vision clearance standards pertain to an intersection of 2 streets or a street and a driveway. And it's basically, there's a triangle area where nothing's supposed to be above 3 feet except for occasional tree or pole. So you have good sight clearance. It's a hazard prevention thing. But in the Holton Business District, just like down here at the Riverfront District, where that's a challenge when you want buildings to be up against the street, that provision is exempt. So the landscaping that you kind of see in the photos here was originally installed, I think, during the days when the vision clearance applied. Now it doesn't. The reason I bring that up is one of the things that the applicant talked about on the side. It's not in the application, was in lieu of having a vegetative screening, having a fence along South 15th. So that's one of the things I think we should have as an option for flexibility. But let's say that that is an allowance for screening along 15th Street. If that provides the screening, do we need the landscaping? And then do we need the street trees or not? So it's a should there be trees or not question. Now, another thing about screening, and part of the acquisition of this property is inheriting some of the requirements that were in place, which includes the fence along the south side that provided a screen between the residential property and the parking lot. And it's a fence, it's been there a long time. Some pieces have broken or have fallen off since the recent owner acquired it. And so one of the things we talk about this report is repairing that fence so it once again provides a contiguous screen. And in our preliminary discussions, that's why the owner brought up, well, could I screen South 15th Street? Now, when we talk about the differences between general commercial and Holton Business District, another important consideration is back in the general commercial days, there was a 10% minimum landscaping requirement, so plants and stuff. With the Holton Business District zoning, that changed to open space, again 10%, and open space is a much more lenient provision. Doesn't necessarily have to be plants, it's just area set aside, not used for anything else. That can be met pretty easily. One of the reasons I bring that up is when we look at what was there before and when the Holton Business District zone took effect, one of the provisions of the Holton Business District is that the building has a maximum 0 front setback. The objective of the zone is for buildings to be up to the street to help with your streetscape, street life, things like that, rather than way behind. And there was landscaping between the building and the sidewalk. If the planning commission was receptive to the parking lot being screened by a fence as an option, not necessarily the owner requirement, it could be landscaping or a fence. I believe that landscaping should be required between the building and the sidewalk because that's what ties in that 0 front setback. The code talks about the building or the area in between being pedestrian amenities. Whether or not the landscaping is a pedestrian amenity is something of debate, but we know it was there before, and that was kind of the tie-in. So that at the very least, that's where there should be landscaping. Now, whether or not there's a tree in there or not, I think that's something we should discuss. So should street trees have been required just based on this addition? If it was brand new development, I would say 100% for sure. Another thing in thinking about the flexibility, so this is based on this craftsman use. And it's a little more wordy in the code, but I'm just paraphrasing for easier speech. That's very minimal parking. To permit flexibility for a tenant, I think it should be based on the amount of parking that will lawfully fit on the existing paved area. That just opens more options. The reason for that is if we just say this is specific to a craftsman, because it's based on employees and some new use comes, we could go, well, that's more parking. You need to go through a land use permit again. And I'd like to provide a little bit of cushion to avoid that since it is existing development. So those are things that are articulated in the report. I just want to make sure I got that out. So everybody who will comment can talk about it, and so we can talk about it at the deliberations. We get into a lot of details about putting the puzzle together, walkways and open space and stuff like that. I'm not going to get into that too much. If there's testimony on that, we certainly can. But the big things are making sure we have the right screening in there, we have the right parking design. I want to talk about the trees or not. And that I think is, there's more subject matter in the staff report, but I think we can take that on as or if we need to. So I'll let that conclude. Oh, yeah. And because it's a conditional use permit, there are extra conditions that you can apply. Because the trigger for the conditional use permit is the outdoor storage. If you felt additional conditions were warranted, it should probably focus on that aspect. For example, well, they need to erect a statue. That has nothing to do with the open, with the storage. And so there should be a nexus with the outdoor storage for any additional conditions. But we'll see what we hear and let that navigate the discussion further. That's what I got for now.
Thank you. Please remember, we can ask questions at this time, but cannot deliberate until after the public hearing is closed. That said, does the commission have any questions of staff? Do we have an applicant's presentation?
My name's Al Peterson, Icon Architecture and Design. I'm here representing Andrew Christensen, who's the property owner. I have extra copies of the plans here, which I do want to provide you to go over a little bit. I do have a bit of a concern. And I guess I'll raise that initial concern with a question. So this is the site plan, which you should have, and I can provide you with larger paper copy if you would like. But based on what you just heard and what you've read in the staff report, do you believe that the recommendation is to accept this site plan as presented? You want bigger ones? Hey, Shelley, I'm gonna have to take one of them so I can use it.
Can you ask your question again?
Well, my basic question is, based on what you've heard so far and your reading of the staff report, do you believe that what was presented and what the staff report says, because it recommends approval. So do you believe that that approval is based on the site plan we presented?
You had a question that Jake would answer.
No, I'm asking you because my problem with the staff report and the presentation is in the staff report, there is writing that basically says we have to redesign the site plan, which I disagree with. Whenever I normally go to, when I present site plans, I present site plans to the planning commission and either there's a recommendation to approve or recommendation to deny based on the site plan. But in the conditions of approval, there is a bunch of language that says we have to redesign. And we did not request to you that we have to redesign.
I think we do approvals with conditions quite
Well,
often.
right, but this is the conditions that are in here are basically to redesign it. That's not what we asked for. So I'm going to go through the staff report and address some things. But my main point is the building was built in 1920 based on the county assessor's office. I went up there to check. I'll just follow off of what Jacob said. I grew up in St. Helens. In fact, that photograph that's up on that board, you see the St. Helens Catholic Church behind. That was the St. Helens Catholic School before they tore it down and rebuilt the church. I went to that school. I'm very familiar with this area. Every day I walked from that school, basically this way on the picture, going down Cowlett Street to my aunt's house on 17th Street, or if she wasn't home, we'd go to my grandma's house over on Clark Street. So I'm very familiar. This property was in fact Farney Trucking property. That was the Farney Trucking shop, and all of the lots around Farney Trucking at the time were all gravel, and they were all full of either trucks or trailers or whatever, and that was their maintenance shop. So the entire property is gravel. Over the years, grass grows up, blackberries grow up, all kinds of different things grow up, but essentially the whole property was gravel. Now, on a site plan, you can see there is one mistake on the site plan, which is at the back of the building, and I've crossed it off where it says gravel. That entire area from 14th Street all the way to the building is currently paved. That area north of that paved area is currently gravel. The area to the south of the building, there is an existing paved parking area, and you can see in these photographs, there's no striping on it. Even when the previous property owner had it, he didn't get around to striping the parking lot. But the parking lot, as I say in my presentation, in my written narrative, that parking lot has been there as far as I could tell from the assessor's office, as far back as 1987, probably before. But in the assessor's office, the records only go back to 1987. So the discussion, and I realize that the current property owner is a little bit cantankerous with city officials. But what is on this site plan is what he has prepared to do. So the city code requires streets or street trees. And that is what's on the site plan, and that's what he has told me he's prepared to do. The staff report takes a lot of time talking about the existing planters. And there's a little bit of semantics going on here. Because the staff report goes on and on about how the planters were removed. Well, the planters are still there. The landscaping's gone, but the planters are still there. It's just a hole in the asphalt and behind the sidewalk. So landscaping can be easily put back. I don't know the rationale as to why it was all ripped out. I don't care, frankly, but what is shown on the site plan is what is being proposed. Now, regarding the existing, and now I'm going to get to why I'm saying that what we presented is what we want, or what Mr. Hunter wants. So in page 8 of the staff report, it goes on about the parking lot south of the building. And as I've said, that paved area has been there since at least 1987. So it was approved at some point by somebody. Because the city of St. Helens has had zoning much longer than that. So if you had a chance to read my presentation, which is on page 5 of 7 of my presentation. This is an existing non-conforming parking lot. And all we're asking is to restripe it in a reasonable manner for parking. That's it. However, in the staff report, at the bottom of page 8 of 13, and in the recommendations on page, or in the conditions on page 12, Jacob on page 8 is basically redesigning the parking lot, which we didn't ask him to do. And not only that, he's requiring that we redesign the parking lot. We'd rather not redesign the parking lot. And it's our contention, and I'm going to go ahead and read it, that this is an existing non-conforming parking lot, and there's no reason to redesign it. It's existing. So the property line on the south was platted in 1845. And to our knowledge, based on my look at survey records, it hasn't moved. The building, according to the tax assessor's records, was built in 1920. It hasn't moved. The parking lot, as I said, goes back to 1987, so it was approved at some point. We are not proposing to enlarge it. We are not proposing to change it. All we're proposing is to restripe it so that we can have an ADA parking space and additional parking. Now, the staff report is focused on current standards. Current standards are usually based on designs which tend to come out of parking lot designs, and they also fall into, when you get into parking garages, the standards, the minimum standards actually work very well for parking garages, and you end up with 60 feet. Well, people have been parking in this parking garage, in this parking lot for quite a while. It's an existing condition, and there's no particular reason that we should redesign the parking lot simply because somebody wants us to. I did say in my presentation, and if you look at the site plan, the basic problem is that from the building, where the building is currently located and the south property line, we're restricted. We have less than 60 feet. So it can't conform to the magic 60-foot number. What we have done is we've made the parking stalls 10 foot 4 inches wide so that you have extra maneuvering room when you pull into a parking space and pull out of a parking space. And that allows for, because the standard parking space is 9 feet wide. And trying to turn a right-hand corner and get into a narrow 9-foot space is difficult. I'm sorry. So what we're proposing is simply to make the parking stalls wider so that there's more maneuvering room. You can back in and out, because instead of there being more maneuvering room in the drive aisles, there's more maneuvering room in the actual spaces themselves. So that's what we're proposing. And we strongly disagree with what's in the staff report on page 8. I think it's page 8. Where staff has proposed a redesign of the parking lot, a walkway along the south building, which basically takes out the area where you can park, because then you clearly don't have enough space. And just use the available space that you have now. So, to my knowledge, what Jacob brought up related to fencing, this is the first time I've heard of it. In all my conversations with Hunter, it has never come up. So as far as street trees and landscaping, that's what's being proposed. And it's my understanding that my client is willing to do that. He's willing to put back the landscaping. He's willing to plant street trees, and we're proposing Pacific dogwood, which is a native tree, so it can survive in this climate. Let me see, I can get back into this step. Number 2I, it says open space shall be specifically identified and quantified. The site plan shows all the open spaces. It shows the existing gravel areas and grass areas. It shows the asphalt areas, and it shows the existing gravel area in the south. So we're already showing it. So I don't know what that means. And my question is, well, are you approving this site plan or not? All walkways, vehicle ways, and off-street parking shall be paved. We're only proposing a parking lot here. The only 2 additional things that we're showing is a new walkway from the back door over to the existing asphalt. There's a side door over here, and in the staff report and in the photographs, Jacob points out that that door was not there in 2014. Well, I'll be honest, I don't know when that door appeared. I drew the plans for Mr. Fortier, who was the previous owner. At some point, he must have decided to put in a door, and he didn't tell me about it. So it's existing. For me, it's existing. So we're showing a walkway from that. There is existing concrete at that walkway, and it comes over to the existing paving. You can't see it in the photographs. I don't think even Jacob's photographs show it, but I'm telling you, I went out there. I had pictures in my office. There is the existing walkway and just past the door, it stops. And we're just proposing the walkway that goes along the building to the south and to the back parking area. Or to the back asphalt. Now, the other reason that I'm sort of, the staff report talks about walkways and how walkways need to be connected and talks about how, let's see, let me get to it again. Somewhere in here. It says the walkway, I'm not sure which walkway he's talking about. This is on page 10 of 13. In the middle of the page. Says, as the walkway exceeds 36 feet in length in a parking lot area, 6 inches vertical or 3 feet horizontal, vehicle area separation will apply per 1784-50. 1784-50 specifically talks about entrances and a walkway from an entrance to a public way. The main entrance of this building is right there. And the walkway, the sidewalk is right there. And now, of course, there's this new door there, and there's a piece of concrete, which you can't see, it's right there. Which is, we're proposing that the walkway goes to the back end of the property to the existing paving in the back. The reason I'm bringing this up is the normal intent of both the building code and, in my opinion, the zoning code is so that pedestrians can get to the main entrance. That's usually the case. In some cases, when there's a required fire exit or something like that, in those cases, the fire exit, oftentimes you need to get from the exit, the fire exit, to the public way. Though that's the intent of both the building code and, in my opinion, the zoning code. There's nothing in the code that I have found that says you need a walkway connecting two different entrances. It doesn't say that. So in this sketch that you see in this staff report, he's basically connecting the two entrances, which is not required by the code. Now, number 5 on page 12 of 13 says plans will be properly calibrated to existing, and then he names a survey. I have a copy of the survey right here. This is the survey. This is from the county surveyor's website. We downloaded it, and I've highlighted all the property line on my drawing. Those dimensions on those property lines exactly match this survey. So I don't know exactly what dimensions I'm supposed to match this survey, because if you read this, and I'm just going to pass this around, you can read it. The dimensions on my drawing match the survey. So I would like that particular condition removed. It already matches. And then the last one is what I have been talking about. The last condition, number 6. Parking lot design shall be updated based on actual physical space available, previous or new survey information. And to ensure maneuvering, et cetera, et cetera, et cetera. I've already talked to them. I think that this site plan achieves that. We've made the stalls wider so that people can maneuver. Simply because the 2 drive-out lanes are a little bit narrow, you can still maneuver in the parking spaces. And I remember when I was on this commission, sitting in those chairs, we were having this pretty much the same discussion. And so the applicant at the time said, well, I'll come back next time and I'll show you a video. And that's exactly what he did. He came back to us with a video of him driving through an area we did not think he could get through. So we approved it. So I'm just showing you that I believe this site plan works because we have provided extra space. I do not think that this walkway is necessary, and it's not necessary because this is an existing non-conforming parking lot. That's all I have to say.
Okay,
And I will say lastly, they're asking that you approve the site plan that we presented.
anything?
House, I know the sort of, yeah.
So next, do we have any testimony in support of the application? Oh, we do. Online.
Hello there. Can you hear me?
Yes. Can you please state your name for the record?
Yes. My name is Erin Salisbury. I am the Executive Director of the St. Helens Main Street Alliance, and I am here tonight in support of this conditional use application. I want to speak to what I believe is the heart of this decision. A building in our downtown corridor, our uptown portion of that downtown, has been sitting empty for 6 years. Empty buildings don't just sit still, they age. They signal to visitors and our own residents that downtown isn't quite ready for them. They represent lost opportunity for the property owner, for potential tenants, and for the neighbors around them, as well as for the tax base that supports the city services we all depend on. What's being proposed here is genuinely a good transition. This building has a working industrial history. It served our community as a place where things were made and crafted. An artisan workshop space honors that history. It's not a dramatic change of character, it's a continuation of one. I recognize that there are technical disagreements before you tonight about site improvements, about what level of upgrade is appropriate and proportionate for this change of use, or reactivation of use, perhaps. I'm not here to pass judgment on that, but I do want to offer this perspective that when a non-conforming property has been sitting dormant for 6 years, the standard we apply to bringing it back into use matters. Conditions that require significant new site redesign beyond what is reasonably necessary can make the difference between a building that gets activated and one that stays dark. The architect's position that restriping the existing non-conforming lot is sufficient to move forward represents a practical, proportionate path to getting this building back into commerce. I'd encourage the commission to weigh that carefully. Whatever you decide on the technical conditions, please make them clear, specific, and achievable. This approval is only the first hurdle. There is still permitting, improvements, and build out ahead before anyone sets foot inside as a tenant or potentially as a customer, though we understand that this isn't going to necessarily be a site for active commerce. The conditions attached to tonight's decision should light the way forward, not add another obstacle to an obstacle course. St. Helens benefits when its buildings are occupied and active. A workshop, any kind of industrial use in this corridor is exactly the kind of use that our downtown needs more of. I hope you'll find a path to a yes tonight and keep that path as clear as possible. Thank you.
Thanks, Erin. Do we have anybody else online?
No one else has raised their hand.
Okay. So next we have, do we have any neutral testimony? Those who are not in favor or against the proposal, just have information? No? Okay. Do we have any testimony in opposition to the application? Okay. Oh,
Hello,
hello.
Stephen Toski, citizen of St. Helens. So I want to say that I'm for a lot of this application, but I'm very much against certain specifics of it, which are outside the law. And so it's important that we start with what the Holton Business District is, and we understand the parameters of what your decision needs to be within. The Holton Business District is in a special zoning district in St. Helens where we're attempting to get mixed use and residential together in order to promote this sort of commercial residential district. And that is contained in zoning 17.32.140. The strategy is to provide opportunities for traditional neighborhood design and mixed commercial uses. It's to revitalize older developed areas by eliminating certain nonconformities, providing for more mixed use development in individual buildings. Those are part of the thing. So what we're trying to do is eliminate these nonconformities. So I don't know, the old trucking company, bye-bye. A car repair shop with a bunch of cars scattered all around the neighborhood, not a conforming use. And so the Holton Business District zoning laws have very specific uses set out. There's a number of conforming uses which are automatic. All of the automatic uses prohibit a outside storage component to them. So if someone came here and said, I want to build an artisan workshop with outside storage, they would need to get a conditional use permit. So trade in skilled services with outdoor storage, such as plumbing, HVAC, electrical, paint and facility shop. So if I wanted to say, hey, look, I want to open an HVAC shop, you guys, and with outdoor storage, it would have to go through the conditional use permitting process. And so what happens in the Holton Business District is attached to the use of buildings. And what we have here is an application saying, I want an artisan workshop with storage. Okay, now, all the other stuff about the plants and the trees and all that other stuff, leave that all up to y'all. The fact of the matter is that they want this storage component, which is one of the major issues that we have with light in this town. We just eliminated a very large RV storage unit on the block where now the new police station is going. We had an entire city block dedicated to RV storage. The city is investing 12, 15 million, $17 million into removing that non-conforming use and building a brand new building, which hopefully will spur further development in this area. This particular building is a building that has been blighted for many years, and I'm happy that the owner is trying to put money into it. It was a place that was occupied by the homeless. Now it's been boarded up. So what we have now is another boarded up, blighted building. It's still a blighted building, it's boarded up. So what the owner of this building is coming to you before is saying, I want a conditional use permit. Conditional use for an artisan shop. If it wasn't for the storage component, they wouldn't even need to be here, but they want storage. This is where I'm coming to. A lot of the storage they're asking for is something you can't give because it's against the law. Okay, so when we go now to conditional uses, special conditions permitted and conditional uses, outdoor storage of goods and materials must be screened. And businesses with outdoor storage, those businesses in permitted uses. So basically what we're here for is because they say, I want an artisan workshop, but I want storage. And so you're allowed to say, yes, you can have storage, but your storage is limited to storage for your business use, and it must be screened. So if I'm an HVAC person and I want, which is a permitted use, and I want to be able to store my HVAC units that I'm bringing in as materials that I'm going to install a year from now, 6 months, whatever, or conduit or whatever that I need, you could allow me to do that, but I would need to screen that. Okay, all right. So the conditional use would be, yes, you can run your HVAC unit shop. Yes, you can have your storage, but it's got to be screened. So what I'm objecting to is portions within the application that have sentences like tax lot 4N1W4AC5502 remains as is a half-paved paved gravel empty lot used for vehicle and other storage purposes. There is nothing in the law that will allow you, as part of an artisan shop, conditional use permit, to allow somebody to just store vehicles and whatever other stuff they want on this lot in the Holton Business District. Let's not go backwards and have a bunch of junk cars, crud trailers, RV storage on this lot in the Holton Business District. I like the idea of an artisan workshop. I like the idea of screen storage for an artisan workshop. What I don't want, and which is part of their application, is this half-paved gravel empty lot. That's outside your purview anyway. You can't say you can have storage beyond what you need in your business.
Hey, Steve, what page are you reading from?
I'm reading from your application. I honestly, I didn't bring my computer, but I mean, if you want to address the storage stuff, I honestly, you're going to get my point here. And so,
Well, yeah, I'm getting it. I just wanted to be accurate.
okay, so tax lot 41 4AC 50502 will remain as is. It will be fenced with privacy fencing and will be used for storage of raw materials and finished product of the business occupying that. Sounds fine. If it's an artisan workshop and this is going to be for storage of raw materials and finished product, that sounds like an allowed use. Why not? As long as it's screened, okay? The rear lot will continue to be used for storage as it has been the case for more than 50 years. Absolutely not. I don't know if that's the one with the giant trailer sitting on it right now that has gang sign on it. That's got to go. So there is nothing in the law that would allow you as the planning commission to simply wholesale as part of this application. We're going to use this for storage like we used to do. We're trying to get rid of this stuff. We're trying to make this into a vibrant commercial district. So I am for artisan workshop. I am for the planning commission placing a condition as if you, which they're asking for storage, say, A, we're granting your application as an artisan workshop. B, we're granting your application per staff approval of screen storage for the artisan workshop. No other storage is allowed because there is no other storage allowed under the law. You can't just store stuff there. So I think it's very important that we don't go one step forward and 5 steps backwards. The days of old are gone. And I commend the owner for getting a start on this. And I'm hoping that working with the city and understanding the goals of what we're trying to create here is a vibrant commercial district that is both residential and commercial, and an artisan workshop is great, but I'm against these storage things. And I think that as part of your, if you're going to grant the conditional use permit, that you make sure that you emphasize that whatever storage is allowed is attached to the artisan workshop business. And you will deny the application as far as the half paved gravel empty lot used for vehicle and other storage purposes, no. And that as far as the rear lot is concerned, that would be used for storage, as has been the case for more than 50 years. That is a denial because that is part of the conditional use permit. So last thing we want to do is grant this artisan workshop and then dovetail in where we suddenly are wondering, why do we have 20 junk cars parked out here? Okay, so there, I've made my points. Thank you.
We have another, yes,
Hi.
you can please state your name for the record.
Yeah, so my name's Lena Coy and I'm that house right there, the 196. Okay, sorry, I get nervous, so I'm just gonna read my. Okay, so we've lived there for since 2015. So we lived there back when it was the Columbia, what is it, River Mandrel or whatever. And we never had any issues with them. So then, immediately after Mr. Christensen purchased this property, he began work on it. So the first thing that he did was he removed all those metal barrels there in the back. They're all under those sticker bushes. And so I would say there were probably roughly 100 of them. And they were filled with, I'm not really sure, unknown substances. And that, over the years they sat out there and were exposed to all the weather. They were leaking because during the summertime, you could smell the oil. It's pretty bad. And so, I'm sure spills occurred during the removal as well, because after that first rainfall, we would see oil pooling in the backyard, something that we had never seen before. And I think partially that was due to that gravel portion. That where those barrels sat, he graded it with his skid steer. And so now the property slopes towards the back end. And so, we're seeing significant water coming from his property to ours, starting at our shed, which is like right there, but all back there. So it's all running under the fence and then into our shop. And so, but that never happened prior. So here's the shed and the shop, and it's just running back into. And then, so then there seems to be like a little bit of complete confusion on what these planter boxes are. So it's not flat. There is like a 6-inch cement barrier on all of these. And so when he ripped those all out, so it's a big giant hole. And so there's also flooding into the front because, so he removed those flower boxes and apparently he was advised not to. Jacob told me that, he said, don't those acted as a deterrent for the water. And so now with all those removed, the water free flows, because this part is sloped. And so this kind of acted, it would slope into that. And so now the sidewalk is pretty much a river at all times during the fall to spring, pretty much unusable. And we're also seeing the oil runoff. So much so that we keep a bottle of degreaser on our front porch to spray it. Because, you know, I don't want my kids stepping in it. I don't want it tracked in my house. Pedestrians avoid walking on it. They'll turn around and they will walk on the road instead of doing it. So then since he's created this big hole where that landscaping was, all this silt is also now free flowing down the sidewalk. And so all that muck is getting caught. So we're having to do all the cleanup on that because, you know, that's a potential safety hazard for, you know, and if someone gets hurt, you know, that's a legal liability for us. Let's see. And so then I also want to talk about the fence. So in November 24, when he was removing those planter boxes, he nicked the fence with the skid steer and he tore down, I don't have any pictures, but he tore down this front, like the wood area. The beams are still there. So then I went out there and I was like, you know, hey, broke my fence. And he's like, yeah, I'll take care of it. 5 months later, still hadn't. So I went out there, had a conversation with him. He went out there, he worked on it, said he'd be back soon. Year later, he still hasn't been out there to do anything on it. So, you know, pretty much the fence is in terrible shape. All the slats, any sort of wind, they blow over. So, you know, that it's not going to act as a good barrier between our properties because it requires, you know, constant upkeep because it's just as rotten and falling apart. It just, you know. So ultimately, you know, putting up a new fence would be required, but it's not going to solve the water and drainage issues that needs to be addressed in the property. But altogether, you know, we're not opposed to him, you know, having something there. You know, we would be naive to think that it's going to sit there forever. And honestly, it does look better now than it did when the homeless man lived there, you know? But our concern is that if this permit gets approved, he's going to completely disregard any of these issues that, you know, are causing damage to our property, and won't take any responsibility for anything that he's caused. You know, and when you try to have a conversation with him, he just, you know, he says that he doesn't have the time. And I feel like, you know, during his ownership of this property, he'll just, you know, he's worked with when there's stop work orders, he'll work at night, even though, you know, I call and do noise complaints, you know, he'll remove your guys' property and then just be like, you know, so I just feel like, you know, my family's kind of at a loss of what to do because everything's out of our control because all this flooding happens prior to our property. Like there's nothing we can do to stop it. We can't, you know, we can't block the sidewalk. So, you know, I mean, something has to be done here. You know, because we're in a hole here. So all this slope of water just, you know, we just get it all. Okay.
Thank you.
We have anybody online who is in,
Raise their hand.
okay, so now we have, we'll allow for a rebuttal by the applicant.
First, I'll address Mr. Toski's comments. This is a conditional use application. That's why we're here, because we're asking for site obscuring fences. And the site plan shows the site obscuring fences where the storage will occur. I went and I read my application that Mr. Toski quoted, and I have been misquoted. I'm going to read it. New tenant intends to use the building as a woodworking shop for his trim and molding business. Just like previous approval, the building is small. The tenant runs a one-man shop. The proposed use is the same scale as the previous approved use, artisan workshop. And in this case, artisan workshop is a permitted use outright, and an artisan workshop has a permitted use outright and have outdoor storage as long as it is screened and the site plan shows those fences, which are site obscuring fences. I'm going to continue reading. The proposed use is the same scale as approved use, artisan workshop per 117-132-82P, which is an allowed use in the Holton Business District. The rear lot will continue to use as storage as it's been for 50 years. My intent was obviously that it would be used for storage for the workshop. And somewhere in here, I think it says that it's going to be used. Oh. I did not find it, but somewhere in here, it says that the outdoor storage will be for the products that he will be working on in the shop. I did not say anywhere in my application anything about automobile storage. We are not asking for automobile storage, and my words have been misconstrued. So the site plan shows specifically a site obscuring fence, which complies with the ordinance. The application specifically talks about an allowed use outright. And the storage for that allowed use will be the products which he's working on inside the shop. I cannot address the issue of the barrels that were from the previous owner. I just can't. And the person that testified said that when Hunter, who's the current owner, bought the property, he got rid of all those barrels. And I believe Jacob shows the property cleaned up. When this supposed leakage occurred, I do not know, and I can't address it. I do want to say something about the water. I don't know anything about the back of the property. We do not have a topographic survey, but the property is pretty flat. However, in the front of the property, the street out here, like all streets, has a crown in it, so that water drains off of the street. And you can see the fog line here. So the crown of the street goes past the fog line, I expect, to that joint right there, which you can see on this drawing. Now, what happens in this street, I have been there because this issue has been brought up. I have been there when it's raining. What is occurring is water from this street and this way is uphill. Water is coming off of the street from the crown in the street. It's coming over here, and this asphalt over the years, rather than grinding streets like they do now, the city over the years, and then the people along here have been paving pave, over pave, over pave, and now this pavement is level with that sidewalk. And in fact, when I went out there in November or December, somebody had put in little sandbags from right there across there. Basically trying to keep all of the street water from running down this crack, because this is actually the low point, that crack, running down this crack. And about here is when the water starts to move across here, across this sidewalk and onto that property. That's an existing condition. So the majority of the water at the front of the property is actually coming off of the street. Now, this low spot could be fixed if it was regraded south, because at this house, the closest storm drain is actually on the corner. So the sidewalk goes around the corner and the closest storm drain is right down. So basically, all of this street water coming off of the crown, moving over here into the low spot here, going this way and working its way across both the sidewalk and into the. So that's what's happening. I have photographs of that, but I just didn't bring them today either. So to get back to the rebuttal, what I have asked for is that the application be approved as staff recommends. However, we request that it's not very specific in this these conditions. However, condition number 6, which specifically talks about the parking lot being redesigned, we request that you take that condition off. It's an existing parking lot. It's been there since at least the 1980s. We do not feel that we should have to redo the parking lot because it's an existing condition. I request that you take off number 5 because, as I've shown you, my dimensions on the property line match the survey. Now, the thing about the refuse container, the refuse container is going to be behind the building inside the screened fenced area back here. I don't think it's a problem one way or another once he gets the fence built. That's all I have.
Well, while the public hearing is still open, probably talk about something.
Okay. Finances, does the group have any questions, but yeah.
So the first thing about the survey. I'm trying to help the applicant out. I'm not trying to dispute the dimensions. The issue is where is that polygon as it relates to existing improvements? Based on a discussion with the owner who talked to the county surveyor and looked at those, it got us thinking, well, maybe these planters are not within the right of way. And perhaps if the plan was properly calibrated, that would be less permitting required. If it's not in the right of way, you don't need a right of way permit. One of the concerns early on is that those were in the right of way and would have required a right of way permit through our engineering. If it can be shown that they're not, that's less bureaucracy. So that's the idea with the survey. As far as the walkway, it's not an existing condition. We have the evidence in the staff report showing that that door was added after 2013. It did not exist in the 50s, 60s, 70s, 80s, 90s, 2000s. It showed up later on. So then where does the walkway go? One of the things we have to consider in site development review is crime prevention. One of the things that the owner talked about was people cutting through the
Can I
property.
object for a moment?
I would like to finish my,
No, I'm sorry.
He's speaking for the owner.
He
He is
gets,
not speaking for the owner.
I'll just let him finish, then we'll,
the owner talks to me. I'm not trying to throw him under the bus. I'm just talking about the things he talked about. So he talked about people trespassing and, wanting that fence to prevent that. But so the reason I bring that up from a crime prevention standpoint is, well, let's talk about the walkway thing. Because the code doesn't say main walkway. The code says walkways, and it's plural. So we're simply trying to follow what the code says. The excerpt on page 10 is taken directly from the Helens Community Development Code. And this is a provision that's existed for a long time. Walkways in plural shall extend from the ground floor entrances, also plural, or from the ground floor landings of stairs, ramps, or elevators of all commercial, institutional, and industrial uses to the streets which provide the required access and egress. It's plural. You're connecting those walkways to the streets. This is something we've exercised a multitude of times. So the reason I bring that up from a crime prevention standpoint is the plans do not show if there's a walkway that was for the purposes of going to 14th Street, that's not identified. If it was identified, okay, then where's the man gate? And from a security standpoint, is that where you want a man gate, which may be locked at many times and may not be accessible? So the practical path is to 15th Street, which provides the main access to the building. We're simply trying to honor the code. So the walkway is new because of that man door that was added. And we have additional man doors on the back too. So if that wasn't the case, I think the grandfathered argument would be brilliant. But as we can see by the photographs, this man door showed up. So we have to acknowledge that, because that's our job. We're considering the safety of pedestrians. And as far as it being arduous, it's just different lines on the plan, which is pretty normal. I don't understand why that's this grand requirement. It seems pretty minor. It's just a little bit of different line work within the existing paved area.
I would like a chance to rebut.
And that's why I thought having the public hearing kept open, so I would have a chance to do that.
yes, and that's fine now, but we let you say your piece without interruption, and so Jacob gets to say his. Does anybody have any questions? Any commissioners have any questions for staff or the applicant?
I do what I'm trying to formulate it, so I don't know if anybody else, has any to ask while I try to formulate.
I guess if we're talking about parking spaces, if we do have a walkway in the way,
how would the new parking space layout fit? I guess is where would those lines have to go?
Yeah, so that's why I created the visual on page 8. The intuitive place for that to go would be towards 15th Street. So the minimum width for a walkway is 4 feet. The other thing that's gonna do that I didn't talk about in the report is we don't want to be prejudiced against our disabled neighbors. If we don't acknowledge that walkway, people in a wheelchair will have to go into the drive aisle. If that walkway is there, it allows someone who's disabled to safely navigate to the main entrance. So the minimum width for a walkway is 4 feet. And what the code talks about is when it crosses a vehicular area, parking lot area, more than 36 feet, I think was the number, then there's an additional provision. Either it's a 6-inch vertical provision, so like a standard sidewalk that's 6 foot above the standard elevation of the parking lot. Or you have an additional 3 feet of horizontal clearance, so then that 4 foot becomes 7 feet. In this case, you know, with some wheel stops, you could achieve it. But that is what that's talking about.
Patrick, did you have your?
So I guess just one wondering I have, I don't know, it was Ms. Coy, was that testimony about, you know, what's happening? I don't know if that's like a separate issue that needs to be dealt with code enforcement or whatever, you know, with the, like, if stuff is coming from the other property, that's a separate, I mean, an important issue, but that's separate from our consideration of this, the conditional use permit. That would be another avenue that they could pursue. Anyway, I'm very sympathetic with, as a homeowner, that type of thing happening. But I just wonder if that's something that's addressed in a different venue. But then I'm also want to clarify too about the outdoor storage, and I saw references to the municipal code and all, but I don't recall seeing any specifically to the some of the others specifically related to the Holton Business District. And as I was looking at it, it seems that I'm looking at 17.32.180 parentheses 3E, that outdoor storage related to business is a conditional use that is permitted in the Holton Business District. So I guess, again, I do not want, and I did not hear Mr. Peterson. Also, I did not hear that you wanted to turn this into a parking lot for derelict vehicles or anything like that. I do think we need to be very concerned, as Mr. Toschi said, about the appearance of the district. I live just a block away and would like my neighborhood to, you know, look better than it does. But from what I'm reading of it, and I'm glad to be advised differently, that in fact outdoor storage, if it's related to the business, this artisan business, that is permitted, and again, so long as it is screened. So it's not so much I'm asking if I'm reading this correctly, or
That could be made clear in our conditions.
what's that again?
I said that could be made clear in whatever conditions we put on there. Well, we're getting into deliberation here, so.
Yeah, we can't do that yet. So Al, you had additional comment?
Yes, what this drawing does not show is the entire parking lot. Someone can conceptually say, oh, let's put a walkway there. Well, what are the ramifications of putting a walkway there? You just eliminated these three parking, this ADA parking space and that parking space. And where does it have to go? Well, look at the site plan. You don't have room other than flipping those spaces over to the opposite side of the parking lot. That's the only place on the parking lot that you could possibly put them. Now, the discussion about the ADA parking, crossing, where vehicles are, that's what would have to happen. So now you've got the ADA parking spot across from where the drive aisles are. Your ADA person is basically wheeling himself across the parking lot where cars would be coming in and out. So this is a case where this is the most practical way to put it. The door that Mr. Fortier evidently installed has a concrete walkway. A person in an ADA vehicle has two choices. Either they can get out where it's striped and go in that door, or like any person in a large parking lot, get out and go to the main entrance. And how do they do that? They have to go behind their own car and then over to the main entrance. So this is a practical solution that is the best use of the existing paving. So, I just think that this, redesigning the parking, I mean, basically, we presented what we think is a reasonable plan, and somebody is coming along and basically wanting to redesign it. And that's why I made that point at the very beginning of my presentation. Is this an approval of what we proposed with conditions, or is this a condition to redesign the parking lot? And we are requesting, we think that this parking lot is a very reasonable parking lot. For goodness sakes, it only has 7 spaces. It's not like it's not like there's vehicles going in and out like we're talking about a Walmart or something. It's gonna be safe because you don't have the density of cars or the traffic that you normally have when you're talking about some parking lot where you're trying to get across a drive aisle. So we think that this is a reasonable design. We've added extra wide stalls so that there's maneuverability because we know that the drive aisles are a little bit small. However, I will point out the I believe it's a 24-foot standard on these drive aisles. Standard width of a county road is 20 feet. That's it. Thank you.
Yeah, I just don't understand how it forces the disabled space on the other side. There's still enough room between the planters. There's 8, according to the plans, assuming it's properly calibrated with the survey, you still have a good 8 feet from the edge of the parking stall to the planter, which means you have about 8 foot of ability to shift. So I have a hard time understanding why it forces the disabled space to the other side of the lot.
Can I address it again? We can debate it back and forth if you want.
Why not?
So he's proposing, and I'm just gonna come up and show you. He's proposing a walkway right there. Right? Does that look like that sketch? Okay. Minimum width 4 feet, right? You have existing parking light spaces and the minimum dimension of the parking space is 18 feet. He just chopped off 4 feet of a minimum 18-foot parking space. Okay. The whole discussion in there is about the width of the drive aisles. And the width of the drive aisles, the minimum is 24 feet. Well, if we shift these parking spaces down 4 feet, we now have lost, and according to my dimension, it's 23.6, and he contends that it's smaller than that. I don't care. 23.6, you've now lost 4 feet out of 23.6. You don't even have enough room for two drive lanes.
Yeah, and that's why we're trying to help a brother out by recommending parallel spaces on the south side so it fits.
When did somebody say that?
It's in the report. 8 by 22 parallel spaces.
And how many spaces can you get in?
I guessed about 2 on that south side, so it's a little bit of a reduction.
So you can get 2 spaces back here and that's it. So you're reducing, he's proposing that we reduce a reasonable solution of a parking lot from 1, 2, 3, 4, 5, 6, 7 to 2. That's his proposal.
I just, the walkway, the entry's new, you have to consider the walkway, it's just. If you want to consider the
We're
walkway,
requesting-
if you want to consider the walkway to,
That is approved as presented.
if you want to consider a walkway to 14th Street, we want to make sure it was identified on the plan with a man door. That way, we have a plan that shows where outdoor storage should remain clear for that passageway.
Okay. Does the commission have any final questions? Nope, okay, I think we can close the public record. Hearing no further questions from the commission and no further responses from staff, the public record is closed. And this matter is returned to the table for deliberations and oral discussion or oral decision.
Hear that, we might be tailoring the, this decision towards the use of the, what the proposed use and worry about, future uses after that. It just seems like we're all fixated on the artesian aspect of it. And also with the parking, I go to Walmart, I go to Safeway, and I had to get out car and go behind the cars and that on those things, so it is a hazard that is presents itself in other cases. I'm just not sure with the disabled walk area with the parking there and with the door there, the door that came up from nowhere. That would, they give the disabled person access to that door. The striped area there.
Yeah, I mean, I feel like my first concern is the dimensions of, how far away that building is from the property line. We have conflicting measurements. I also would love to know what's in the right of way and what's not in the right of way, because it sounds like the planters being ripped out has caused a problem. So those are my big concerns. The walkway is a concern as well for safety. Anybody who's ever had anybody in their family that needs ADA realizes that you don't want to be running or pushing a wheelchair behind cars. It would be much preferable to be in front of them. Those are my and I'm concerned about the fence along the south side that was torn down and not fixed. Barrels that may or may not be there shoved into bushes or removed from the side. I'm not sure what happened with those. So those are my concerns.
Oh, yeah, feel very much for the homeowners here.
Especially if he's a woodworker, fix the wooden fence.
I don't think the owner is a word.
Oh, okay, I was like, man. it's
Yeah.
pretty-
And then also, I do think that part of the condition should be a clarification of what the outside storage should be, if that's not already clear in a conditional use permit, which I feel like it is. If you have a conditional use permit for outdoor storage, it states in the code that they can only use it for things that are applicable to their business, correct? So does that get rid of the threat of trailers and boats and RVs and cars and whatever?
Yeah, my recommendation is that would be a condition articulated
So we would.
when this approved.
Okay.
I think if that's the place that the commission wanted to go.
We gotta find a catch-all, that excludes what we want to exclude and include what we want, so.
Yeah.
So this is kind of
I mean, you don't,
tailored.
you don't have to get as specific that it would be for a woodworking shop. You can just say
No.
it's for whatever,
The business.
do like whatever the code says.
I think to that point, when we talk about future use, that walkway makes more sense to insist that it's there.
I mean, the beers could be RV sales, who knows?
So yeah, that's where the storage has to do with the business, I think is good. A good verbiage, right? Outdoor storage must align with the business.
Yeah, but what I'm thinking is that, with the business that, right now it's gonna be woodworking. Future, we don't know what it's going to be.
Yeah, that's why we just say it aligns with the business and
But I mean, there could be a business that might have stuff that the screen won't cover. Words.
true, but if that's the code, that's the code, I guess.
I think it's a question is if you are specific about what's tailored to this business, which would be wood products.
Would we want to be that specific though? I mean, if a different business moves in next week
Yeah, that's.
and
what
they're
I
a
mean.
pottery place,
Still fits.
then the conditional use permit would prevent them from storing.
Yeah, so I think that's a question is,
They have to see.
yeah, if it's a completely different use, like an automotive repair. Is that something that you would want to be able to review again? Or do you want to just have that flexibility? Depending on, where the planets align as far as tenants concerned.
Yeah, I mean, you hate to have somebody have to go through this
Yeah.
just to go through it,
Yeah.
you know?
I'd like to be a little more efficient.
Yeah.
Parking. I don't, can. With the handy, the ADA, in the other parking lot. And the one be eliminated, you put the parallel parking would be the ADA on that, the ADA on that side, parallel parking, you're losing one other part, you still got the 1, 2, 3, 4, 5 on the bottom. So I don't know, is that a possibility of designing, is that a safe thing?
That
They
it,
have the ADA, the parallel one, parallel to the walk, you get the walkway in, ADA is parallel to that, you lose one parking space.
Yeah, that's potential. In fact, now the wheelchair access aisle is always on the passenger side. But if it was intended that the automobile face 15th Street, there's some efficiency there because that wheelchair access aisle could also act as that through walkway. So now you're gaining more space.
I like that. And then all the parking spaces to the south can remain.
Yeah, yep.
I like that.
Now, that could be a suggestion. We don't necessarily need to
Say, this is how you have to
Right,
do it.
totally redesign. We just want to give them tools to help facilitate an efficient process.
The time again with the parking, we're tailoring it to the wood. Because we have a single man and there's, just a few parking spots there. Future use. the Need for, customers for parking that. So it's just a consideration.
Well,
You want to start with the specific requests of the applicant for condition deletions?
can do that. I mean,
And the two that were brought up was the
5 and 6.
calibration to the survey.
Are we talking about 2A, 5 and 6?
Yes.
Yeah.
So the 5 is specific to where the building sits in the property, correct? And also the property lines themselves.
So we know what the dimension is. We have these 3 city blocks. And where exactly are those 3 city blocks as it relates to the sidewalks on each side and the property lines on each side? I just don't know if that was considered in the prior design.
Yeah, I mean, I like 5 just because in my world, things are resurveyed all the time because things are recorded wrong or the maps are old and they get grandfathered, you know what I mean? Like, and we live and die by a property line. So, I like the idea of making sure that those property lines are accurate. I feel like getting rid of 5 is detrimental to the property owner.
We're not trying to be burdensome by saying, hey, you need to do a new survey.
Yeah.
There's a fairly recent survey and some markers out there where the calibration, I don't think would be too arduous. And this is based on a discussion with the owner.
Yeah. What do you guys think?
I'm good with keeping 5. I mean, that makes sense to me and think we make mistakes along the way. Having it validated makes sense.
And I guess if you have 5, ergo 6, right? Like it's updated based on what we learned from 5.
I think her suggestion on the changes to the lot with the way this is written.
Yeah, I agree with Erin. We want to have buildings with lights on and people in them and doing things. And I love the idea of the artisan shop and I hate making things more complicated, but I want them also to be correct.
We want it to be right.
Yeah.
To avoid future.
Yes. And while I don't want to tell people what they can store, I feel like we should also do the best we can to make sure it doesn't end up like the property at 1771 Columbia Boulevard, which was full of random things and RVs for years. And so
we're getting into the type of storage condition that you kind of discussed.
is it clear, is it unclear? I guess I'm unclear as to if the code states that the storage has to do with the business on the site.
That's what I was seeing with the
Yeah, let's take a
Holton, it's in the Holton part of it saying that.
Yeah, the Holton, yeah, and I couldn't find it.
It's really, it's
Oh, So if that's already part of the conditional use permit, then we shouldn't have to do anything.
So under conditional uses, businesses with outdoor storage is what's listed. Now, I've been reading this code for almost 19 years, but that doesn't mean I'm blind to certain paragraphs. But I don't recall seeing something that describes what you're trying to achieve. It says if there's outdoor storage, it requires a conditional use permit that it provides the opportunity for this body to consider the outdoor storage. And I think that's where okay. The conditional use permit gives us that flexibility to kind of examine it. And I think that's the opportunity as part of the conditional use permit to define it if you're so inclined. So based on what I hear, you could just leave it alone, or you could have a condition that says it must relate to the business that occupies the property. Or you can be more aggressive about it and say what the proposal is a woodworking shop. And so the storage must be finished or raw wood products only. That's an example of the spectrum of things you can consider.
Yeah, I think that's a little extreme.
Yeah.
I like relate to the business that occupies the property.
Worried that might
Yeah,
be a little too broad.
That is.
Yeah, but that get us back into what you were saying. We didn't want to have happen and have somebody else move in
With it.
later.
An RV that's
Yeah.
considered business use, for example.
Mm.
So would we want to restrict it to raw materials and finished goods or?
Related to the business proposed in this conditional use permit.
I mean, if you said raw materials and finished goods, that does.
It covers most of the
Covers.
items you would need for a business, but you could have, maintenance materials and other things like that.
I think
If you had a vehicle that you use to deliver your wood products and you wanted to park it in your gravel lot. I mean, that to me is reasonable, right? You're using that to store your equipment that you use for your business. I mean, we don't want to make it so hard for people we want to keep it clean, but we want people to run a hopefully really neat business. Right?
Yeah.
I mean,
I hear what you're saying there.
and I feel like somebody's gonna know I'm not gonna park 4 RVs back here and not pretend that's for my business. Somebody's gonna call them on that. I mean, somebody from
Unless your business is RV storage.
if your business is RV storage, that's true.
RV repaired.
Yeah,
it's ironic, that's what 1771 was,
it's RV storage.
yeah, there's a lot of history there. I'm glad it's over.
We all. So, I mean, I don't know. I don't want to make things so hard. Like Aaron said, we want people to have, good businesses.
Mhm.
So. I don't know, just my opinion. So what do we think? Be more specific or more broad?
I think more specific just for protection in the future myself.
So how would we word that to allow someone to still use equipment that's for their business, but?
I think supplies, materials, raw materials and finished goods,
It's good.
that listing.
Be
covers
up.
Equipment,
Supplies, equipment and raw materials,
finished goods, I think those 4. Is that what we came up with there?
or we could put supplies, equipment and materials that pertain to the business.
I guess materials that pertain also includes finished goods in some circumstances.
And I think if we could, put in language that, with the quantity that doesn't cause blight, something to that effect.
Well,
That's,
also in-
that's,
Way too vague.
that's hard to quantify,
Yeah.
we also be talking about screening though, so we're not
everything always.
thing like
Is there some way like it could be up for review where it's not?
Here's one idea. Outdoors, so outdoor storage associated with the business limited to supplies, materials, and one delivery vehicle that transports those. At least then you're addressing that. I mean, maybe that gets too.
I mean, not all equipment is vehicles.
Yeah.
It's just a
Or
lot of it.
operational vehicles, you know,
Oh.
like we had a tire business and we had 4 forklifts, but they're all broken down. That's not. So they need to be operational maybe?
Yeah. So it could be
Operational equipment.
business supplies,
Covers both vehicles.
materials, and operational equipment.
Like it.
Finished product.
Supplies, materials.
I think materials.
Product is under materials,
Oh, it is, okay.
I think so.
as long as you don't
The
specify.
only thing that I would caution is that the more specific you
Yeah.
get, the more that means anything that we leave off or have in there, you know, is out.
Yeah.
It's just
Now,
drafting 101, Steve.
the one thing we do have in the code is the definition of a wrecking yard, which talks about just a bunch of automotive junk.
No wrecking yard.
So that is a place where if it was just a bunch of automotive junk laying around, that kicks it into a different category. That's only allowed in the industrial district. So that is one thing that we have in the code.
Okay.
I'm glad you brought that up. It kind of reminded me of that.
Like the RV parks where things have to move with a 1 month maximum, you know, stuff like that, so.
At the outdoor storage, we were talking about screening as well. Is that already?
It's all got the
Yeah.
screen.
Yeah.
They're proposing side obscuring fencing.
Yep.
So there's no dispute there, and there's no dispute over the screening.
Do we feel confident in our?
Well, so did we hear hear it again exactly what it is that we are.
Well, where I think we're at was supplies, materials, and operable equipment.
Finished goods too.
That's under materials. I think that'll cover all that.
Specific.
Okay, no.
You got the associated with the business.
Yeah, so outdoor storage associated, outdoor storage shall be limited to stuff associated with the business occupying the site. Limited to supplies, materials, and operable equipment.
I like it.
So with that, you could make a motion to approve with the conditions as recommended by staff and that additional one. Or change it.
You feel ready?
I'm
Are you?
not ready to state it now. Somebody else is going to. All right, I'll move it, I guess. I move that we approve the request with the conditions proposed in the staff report as amended? Or do we need to state that sentence in there exactly?
Well, based on the discussion with the commission, it sounded like you were okay with the conditions. You just wanted to add this new one. So it would be the conditions in the staff report with the added condition pertaining to outdoor storage as we discussed.
I so move.
As stated.
As stated.
Second.
Okay, Commissioner Burkle?
Aye.
Commissioner Kingsbury?
Aye.
Commissioner Herman?
Aye.
Commissioner Gasper?
Aye.
Commissioner Jacobson? Okay, thank you.
And then authorization for signature, if you will.
Thank you. I have more. The final written decision of the planning commission may be appealed to the city council. Notice of decision will be mailed to all persons who testified or submitted comments, and the appeal deadline will be included in this notice.
Was there a vote? Was there a vote in the final?
Does someone have to make a motion for signature?
Yeah.
Oh, pardon me, sorry.
Your motion, yes,
Okay.
sign.
A second.
Second.
Commissioner Burkle?
Aye.
Commissioner Kingsbury? Commissioner Herman?
Aye.
Commissioner Gasper? Commissioner Jacobson? Thank you.
And the reason for that is otherwise we would bring the draft findings of fact to the commission at the next meeting for your review. But we typically do it this way for efficiency to help move things along. It's one way to take a little bit of pain bureaucracy.
Okay.
Okay.
Okay, that's all we have on our public hearing agenda. Does anybody want to discuss the planning director decisions? Number 5. We have an architectural review of 1 Cowlett Street.
Okay, so
Can you take
Do we want to
2
take
or
a
3 or dispatch or?
yeah, it's been a little bit, I think hopefully we'll be understanding that we take a little bit of a break.
Okay,
Yep.
Yeah.
Yep.
Take 5.
8:27,
Okay, 4. Take 4.
take 8:31.
Yeah. That's still 4.
Can we start and he'll catch up? Oh, good, good. Uh, Not that we don't all love being here. Okay, so architectural review for 71 Cowlitz Street.
Yes, so. The planning commission is the acting historic landmarks commission. One of the duties that the historic landmarks commission has is reviewing. Improvements within the riverfront district that aren't historic landmarks, because that's a different path. When there's architectural changes. And Holcomb, who is the owner of the Klondike. Desires to continue to improve the site. This body has reviewed some things. But he's proposing a little bit more. Finish out the project. And I think I will let him and or his architect kind of take it from there, and then we can talk about some of the things I observed from a staff standpoint, and then anything else. So, Holcomb or Jeremy, if you will, you have the call.
I'm happy to walk through it briefly. Jeremy, is that all right?
Yeah, that's totally fine.
So, previously we had approved an elevator addition and porch addition. We had started with that phase because we were intending to do it first and then come here with this second phase and do it. But in the end, what we're doing is proposing the entire second set of changes to bring the hotel to occupancy and open it. So I think what you're looking at is the kind of already historic commission approved tower, and it looks like a big porch. And what we are adding are elements required, some required. So there's an egress stairway. We have to add a second stairway for fire and safety. So that's the portion you kind of see towards one corner of the building. We're adding we're remaking a kind of casual stairway entrance on the alley side of the building into a more formal entrance stair and deck for the restaurant, so that the hotel will have a lobby entrance and the restaurant will have its own entrance. And then we're developing the back interior corner of the property, which is currently a gravel parking lot, into a garden that has a little outbuilding in it that has like amenities for the hotel that includes a hot tub, a sauna, and a treatment room, like you get a massage in. That's like a little pavilion. So those are the elements we're putting forth today. Jacob, did I cover everything?
Yeah, I think that was a good, just kind of overview of what are we looking at?
Yeah, and I think there's one other element, which is that we are proposing a slight aesthetic kind of detail on the tower, which is the elevator. Just because it had kind of a blank face on the top, and more than one person said it looked like what did they say? It looked like an outlet mall. And so we kind of spoke with Joy Sears at State Historic Preservation to see what kinds of, I guess, decorative element we could add that she wouldn't object to. And we added what you see as like a louvers on the tower to make it look a little more almost like a bell tower, just so it had a little less blankness to it. So that is also new, that aesthetic detail. And then, yeah, like the first architectural review, we do, I think, comport with all of the material requirements, wooden windows and doors, matching wooden siding, with the guidelines that are published for downtown. We do have awnings, and I know that Jacob mentions there's kind of a provision about awnings. So on the street facade, we have awnings over the restaurant windows, which is really quite required for the evening summer sun, and those are on the first floor only. The part that I think, is maybe a little interpretive is that on the interior, like the southern rooms and the western rooms, we've put some small awnings over those bedrooms, those hotel bedrooms, for southern and western kind of protection. There's, I consider those secondary. They're technically secondary, I guess, facades since they're not street facades, but they are obviously very visible in the way that the property's arranged on the corner. And then, yeah, the back pavilion. Yeah, there was a note from Jacob about some corrugated. That's not a part of it. We corrected that. It sort of made its way into the plan. There's no corrugated steel on that pavilion. So yeah, I think I guess we open it up to questions or anything you'd like me to explain more, or parts of Jacob's review you want me to address.
Yeah, I'll just go down my little short list and then we'll see where the conversation goes.
Okay.
Where everybody's okay with that?
Sure.
Okay, so the canopy thing. So the mid-belt cornice. Now the guidelines has an illustration that talks about what these architectural features are. Otherwise, I'd be like, I don't know what this is. But basically, let's say we have a building, the mid-belt cornice is, let's pretend that the building is a person and it's wearing a belt. That belt will generally be above the first floor. This is a newer building, so it doesn't have that feature. But basically, the guidelines say generally the awnings are on that first floor. He's proposing ones on the second and third floor. And I just brought it up because of the guidelines. Personally, I don't think it's a big deal. You'd probably want to have awnings if you're staying there. Assuming you agree with me on that, my one comment was there's no awning details. And the guidelines recommend a more rectangular geometry. So assuming that Holcomb is okay with that, and if you're not, we should have the discussion, but that would be one recommendation from staff.
I'm not sure what you mean by rectangular.
Yeah, I have a question.
Yeah. Well, so for example, an awning, basically there are sharp angles to it as opposed to more round marshmallowy.
Oh, yeah. Oh, they're definitely rectangular. They're simple fabric awnings that are sort of rectangles that just are at an angle, and then there's a frame that comes out.
Are they consistent with the first floor awnings?
What was that?
Are they consistent with the first floor awnings?
That's right. They're all the
Yes.
same style. And
That shows on the rear elevation. You can see the side view of it.
And they did look, I'm looking at the architectural design guidelines, it does have specific example, it has specific examples of that in the guidelines and pictures, so sounds what Holcomb's proposing does fit within.
Yeah, they're very much that
yeah,
type.
if you look at detail 1 on the elevations or drawing 1 on the elevations, you can kind of see the side profile of it. It's called out on the patio side elevation. That's the front awning, and we are going to use the same design for all the awnings, was the intention.
Yeah, okay.
Oh, I see.
Yeah, I see.
Number 2 on there.
Yeah.
Yes.
And I think too, even though the guidelines you talk about first floor, this is certainly different. And I think if we want to attract people to have a comfortable stay, we want to keep as much protect from the heat and the light as much as possible. So it sounds like a reasonable thing to do, to have them on the upper floors.
Yeah, we are preserving the single light, the historic glass, and it will help to have awnings in those rooms because the E value of those windows is quite low.
Hi.
High.
Yeah.
It's high. The E value is high. The heat comes through, the radiant heat from the light. So that's sort of what we can, mitigate a little bit.
Any more discussion on awnings?
Some.
Okay. So let's talk about the building facade and the entry. The guidelines talk about original entries. And this building is different because you don't have an entry along the street that's at ground level. So it's different in that aspect. So having a new entrance as he proposes, I don't see any problem with that. The one thing though, sometimes we get excited about the details of doors. And in this case, the door won't be as visible because of the covered entry. Is it worth getting excited over that in this case or not?
The existing door?
Well, it's gonna be, so right now, you access the building, the restaurant, on the side, on the First Street side. He's proposing to change that to the Muckle building or the Waterside building side.
I see what you're saying.
So that's gonna be, and if I'm wrong on anything, holler and correct me, Holcomb. So that's gonna be the new entry. It's gonna be a covered entry, so the door won't be, it won't be as visible.
Invisible.
In prior architectural reviews, we get excited about the kick plate and stuff like that. So my question was, is it even worthy getting excited about it in this case? Because it's not gonna be so front and center as doors typically are.
My question would be, what the entrance is, how long is that entrance that's being used? How long has that been in use? You saying it was an original?
I don't know, do you have an answer to that, Holcomb?
I do. I mean, I think you might know that this was there was the original, where the patio is on the corner was the Opera House, which I believe was relocated from the town square. And in 1909, this building was an addition, so it connected. So there wasn't a door to this building. You went in the lobby of this building and you went over into the building. So when this first building was dismantled in 1951, they built that little glass block and concrete block stair. That's what you may be familiar with going up in and out. And they put a front door on that. In our proposal, that glass block will be removed. The structure will remain, but it will become like an open porch, and the front door will actually be the original entry into the structure. So that would be the hotel entrance. And partly we're proposing that to sort of You kind of have to know that you may know that like when you go into the building, you kind of walk into a little vestibule and then you turn left and you're in like another little vestibule and then you turn left again and you're in the lobby. And the reason is because they built a temporary wall cutting off a rather pretty historic stairway that went up into the hotel when they closed it in 1961. So that whole wall interior is coming down. So what we're trying to create is an entry into the original lobby with the open stair. So you go up that entrance and that'll be the front door. So that is a door that's visible. So that there's a lobby and a restaurant entrance, we're using what is kind of like the emergency exit right now, and we're expanding it and slightly displacing the door a little bit onto the mid block, so that there will be a sign that's a part of a separate permit down the road, an approval process, and that is going to be a covered porch. So that will also help people if they're waiting, can be on the porch. Sorry, I kind of forgot why I'm talking in the first place. But anyway, I hope that was useful information. Both of the doors are called out. They are wooden and they do comport with the guidelines. The front door to the hotel and then the front door to the restaurant.
Well, I think, Commissioner Jacobson, to answer your question, it sounds like the original entry went bye-bye over 70 years ago.
Yes. Thank you. I'm sorry. Yeah.
Okay,
No.
EMI is good when we're talking about historic buildings.
I'm not worried about
No.
seeing the, especially with what we're gaining. What we're gaining, like, we all are gaining it. Okay, really cool.
So you're not gonna stress over that door.
No.
The other question, as it relates to the guidelines, that talks about use of balconies that are not original to the structure. So the new covered entry has an integrated balcony. So it's not a balcony by itself. And I think really that's what the guidelines are supposed to, or that's the intent of what they're covering. They want to have an entry, which makes sense with the weather that we have, and to maximize the use of that as a balcony, as an amenity. It doesn't give me heartburn, but because of the language in the guidelines, I thought it was a good thing to bring up to make sure you don't need heartburn medication for that yourselves.
So that also doubled as a fire escape. Is there a fire escape currently on that side? If I'm not mistaken.
No,
There is.
no, there's
the
the fire
adjoining
escape on the opposite building.
Okay.
Yeah, the Mungo building has it.
Okay.
Yeah, there's not one on this building though.
I mean, everything doubles as a fire escape if you try hard enough. I think somebody could climb down from there, but it's not the intention. It's just like we put the deck up and there's a room right there, and we thought, oh, wouldn't it be neat if they could walk out on here?
And if you don't put a balcony there, they might just walk out in there anyway.
They would just crawl out the window and walk on.
Human nature, you gotta
Edgefield.
anticipate it.
Yeah. Don't doubt.
So then the only other question I had was the materials. Holcomb, you mentioned that the corrugated metal was not proposed.
Yeah.
Well, yeah, it was on there, but then I think we had a conversation last week that we decided that we didn't want to do that. So that was kind of a late design change. I think I had misunderstood something and Holcomb just noticed it last week, I think. So we had some conversations about that and removed it, and that is basically just going to be kind of a, like, where that is called out is just going to be kind of an extension of the platform there. So
Okay, well, we don't have to talk about that. Then we just need to talk about the CMU construction.
Mhm.
Now, they are building on a property line, and so fire rated construction applies. It's not going to be a very visible part of it. So, I don't have heartburn over it. But it was, I thought, at least discussion worthy. See if you concur.
They can't use any other material, can they?
Oh, as far as fire rated construction? I think it limits the material that you use. I'm not an expert at that, so
I'm fine.
then, that's great. Did the commission notice anything else that, staff didn't bring up? Or do you have any questions?
Good with her. When do you think it'll be completed?
Well, I think the main concern is just permitting time, but I think our goal is to break ground by the end of the year and open it by the spring or summer of 28. So it would be an 18-month construction time frame during which we would keep the restaurant open as much as we could. I think there would probably be a month in there that it would close, but hopefully that will be March because March is dumb. and then go through the year of construction. So I'm hopeful that it could be spring or summer of 28.
Right.
Yeah.
Yeah.
The plans sound really good.
Yes.
Oh,
Forward to it.
thank you. Yeah.
Exciting.
I'm excited. I think just having rooms down here and people kind of hanging out year round in the downtown, checking it out and going to the shops, spending money is what we're kind of going for. Also, I think it's going to be a really cool local resource, like come for dinner, stay for breakfast in bed. It's going to really orient around the restaurant, kind of bringing the food and beverage program through the whole property. And yeah.
Jacob, what do we have to do exactly?
Well, you're just giving a recommendation to staff. And I kind of got that.
Yeah.
Based on this discussion. Is this a historic resource review where we have the more formalities of motions and stuff? Unless you want to state something differently, I believe I have what I need from the commission.
I think you got it.
Cool. Well, I appreciate you helping us out, discuss this, and hope the rest of your evening is merry.
Thank you.
Thanks, Malcolm. Thanks.
Thanks.
Okay,
Nice.
so do we have a city council liaison report?
As usual, not much, but we did meet with Romano last Thursday. Those continue to be productive talks, I think. Things are moving forward. It's just trying to figure out a way to make everything agreeable to all parties. Is that a pretty accurate assessment, Jacob?
Yeah, it is. And it's very likely, I don't know when, but based on the methods we're talking about, working out agreements, that the planning commission will see something on that. So you'll be a part of that when the time is right. How soon that is, I don't know. It could be this year, possibly.
So they do seem pretty agreeable to, like, I don't think there's ever been any, they wanna continue on our ideas and building on what we've already done here. But also it's really been pretty, I mean, it's been pretty amazing partnership so far, I think.
So is the city selling the property or leasing? What's that? Because I know when we had, 2, maybe 3 years ago, when we had this discussion, the discussion was
So we're still in talks about that, but we're looking at just basically, what is it, a 15-acre, when you exclude all the green spaces and parks, right? 15-acre, and that's where we're at right now, is trying to figure out how to negotiate that.
negotiate.
So if I don't want to speak, but.
Yeah.
Yeah, it's probably a little early to really.
So that's
Get
still
into those
deciding
details.
but whether sale or whether lease, that's still, okay, no decision's been made that way. Still,
So good. So she says.
I don't want you to say anything out of school.
We saw something with during the joint meeting. They showed a true design, but concept, there you go. Of it. How close to reality is that going to be, that concept? Do you know?
The architectural aspects were totally wrong and they knew that.
Okay.
So the appearance of the buildings, our guidelines weren't really contemplated in that. I think it's a fair approximation. But it's just a visual, like this is the potential kind of mix of uses we can have. I wouldn't get too focused on it.
So the footprint basically is, I mean, the footprint where things are is kind of that, but what's above the footprint was.
Yeah.
There's been discussion about
Yeah.
being able to move some things
Something.
to make it all work, right? And
Yeah.
kind of piece it through the process. That's safe. So like, yeah, you got the concept, right? But it might not be what's there is there. You can move it around. It's kind of interchangeable, but it would all be going through planning, right? To get approved what goes where and all of the features and stuff that we want.
I think that the most important message is there's absolutely no certainty in that graphic. It's just something to whet the appetite of thought.
It's a vibe.
Yes.
And it was very early.
Yeah.
We're vibing.
Conceptual.
Now the kids say.
Pinterest board or
Yeah,
vision board.
vision board, that's it. Okay, anything else?
Nope.
Thanks. For your information items, do we have any for your information items?
Say goodbye to Angelica. This is her last
Yeah.
time.
Angelica.
Thank you for the service.
Thank you.
Thank you so much.
She did find greener pastures.
Best wishes.
Happy for her.
I thought you were gonna be going in the middle of June and rather than next.
Went a little sooner this time.
Oh, yeah, okay.
Okay. Well, there's nothing else then. We are adjourned.
You look for